Don't just focus on just churning and bringing in a huge number of leads and data points. You really want to look at what's the ROI for that data that you're getting, and sometimes less data can yield a better ROI.
Welcome, everyone. My name is Benjamin Farrar. I'm the Director of Privacy, Security, and Compliance at ActiveProspect. This is one of the many content pieces that ActiveProspect is putting together in the weeks and months ahead as we help the lead generation and performance marketing industry navigate the most recent FCC one-to-one consent rules and updates to the TCPA, which is the Telephone Consumer Protection Act. We hope the content we're putting together is going to help you decode these changes with more confidence and a focus on compliance. Today's topic, navigating the new norm, the intersection of TCPA updates, privacy, and the lead generation industry. I will also say today or this week is a special one for privacy compliance officers because it is International Data Privacy Week. So be on the lookout tomorrow for an ActiveProspect blog article about Privacy Week, its growing importance, and details about how we incorporate privacy, security, and transparency in the products and services we provide. And now, for introduction and background, I'd like to pass the mic to our subject matter expert and colleague, Gary Kibel, from Davis+Gilbert. Hello, Gary.
As Benjamin mentioned, I'm with the firm Davis+Gilbert in New York, and I am in our broad advertising marketing practices group and co-lead our privacy and digital media practice within that. So I work quite frequently with all sorts of brands, media companies, ad tech companies, publishers, agencies on all sorts of compliance in terms of their privacy, data collection, processing, and interacting with consumers. And certainly FCC updates are a big issue for people in every industry, certainly those in lead gen and performance marketing, but really anyone who's trying to interface with the consumer that way.
Yeah, excellent. I was really happy to have you here because your experience and the clients and different industries that you advise and impact, it's really a cross-section of all in this ecosystem and lots of different perspectives in that. So really happy to have you today. So for those who have not been paying close attention and focus on other things, what happened over the last month with this FCC TCPA update? If you can give us a quick recap and some of the significant developments, that'd be great.
Sure. So we're hopefully all familiar with the TCPA, the Telephone Consumer Protection Act, and which regulates the making of calls to devices. And many, many years ago, the courts determined that text messages are calls. And so text messaging falls within the TCPA. And the Federal Communications Commission, FCC, which sets the rules for a TCPA, came out with updated rules. And these updated rules were intended to really address the way that consent is obtained and for whom it is obtained when somebody wants to collect a mobile device number to send text messages. And you've heard Benjamin mention and others mention that we now have this one-to-one consent requirement. And there were many tweaks in this new rule that was put out last month for comment, and then will take effect next year. There were minor issues such as how the telcos are supposed to help with blocking of spam text messages. There were issues about email to text technology, which we can talk about in a little bit. But really the most impactful thing was this one-to-one consent requirement, requiring that if someone is going to obtain consent to send text messages, it needs to be that one-to-one relationship between the one provider and the one consumer. Because they felt that in the lead gen business specifically, people had opt-ins for text messaging, which would say something such as, you agree to receive text messages about vacations or about automobiles or something such as that. And then the data would be sold down the line potentially to those brands or to other data brokers and lead generators who would then sell it further down the line. And as a result, the consumer is now getting text messages from many dozens, multiple dozens of companies they may not have ever heard of. And when they gave consent, they may not have realized that they were opening up this Pandora box to get so many text messages from so many unnamed companies. So that key requirement going forward is that in order to get valid consent under the TCPA, and it has to be prior express written consent, which can be digital, doesn't have to be an old-fashioned piece of paper with a pen. To get that valid prior express written consent, you need to identify the party to whom the disclosure is being made on behalf of and who is going to ultimately send the text messages to the client. So I'll stop in a minute, Benjamin, let you hop in, but what that obviously does is that really impacts the lead generation business, because that model I just spoke about earlier, where a consumer might just opt in to receive text messages about vacation packages, that would be a valuable set of data that a lead generator could sell. But now if you have to do a one-to-one consent, it makes it harder, if not impossible, to sell that data down the line.
Yeah, it is challenging, and I'll also mention it's also calls, because a number of this industry space are doing the outbound calling. So text messaging is obviously a growing opportunity and area, but it's also calls. So that's what impacts our industry a great deal. Those doing outbound calling and consent to call. Yeah, I mean, the FCC was not using flattering language when they said we're closing the lead generation loophole. I mean, they were pretty clear about what they were are hinting to, alluding to around that. We've always felt that we were a good service provider, but they don't like that there was lack of transparency. Data was provided by an individual, and then they didn't know where that data was being passed. They had no insight or visibility as to how many times it would be called, and at a certain or text message at a certain point, their framing is that this just can borderline become quite harassing to consumers. Or the non-flattering term was consent forms that they didn't like about the model, saying, you can't land on a website that says we could potentially share your data with any number of entities, which could be over 100. They refer to that not affectionately as consent forms. But yes, that was a significant item and update. So this was announced last month and then finalized in the Federal Register last week. So as far as timing purposes, if people are circle something on the calendar, when are they looking forward to the implementation and compliance timeline towards these updates and changes?
So there was a comment period, which actually I think just ended, and sometimes that may result in changes to the rule. But in all likelihood, this is going to take effect in January of next year. If there is a delay, then the FCC will come out and say that. I'm sure they got many, many comments, but those comments may not have changed their position. And I'm sure that the comments mostly came from the business community concerned about the challenges and what this is going to do to their business and the impact if every consent has to be one-to-one.
Okay. And also, I mean, we have a different cross-section that is attending today. In our previous one, we have individuals that are from large entities and companies. We have individuals from medium and for small business and companies as well. So I also want to highlight, speaking of comments, the FCC did offer an opportunity to present formal comments back to them, because there was concerns about these changes significantly impacting small business. And that was communicated back to their comments, and they have opened up a period for comments for those that are in small businesses to provide their input and share the impacts that they think these things will happen. So we want to make sure that we share a link in our chat here today so people can follow along with that. That's an article that's associated with the REACH Association, which is the Responsible Enterprise Against Consumer Harassment, which is the industry group that's helping carry this message and represent the industries that are doing responsible outreach. And so we'll post that comment here, that link to that article, which will provide some steps and information about, if it's your first time, I expect most of us would be, how to formally provide a comment to the FCC about this opportunity. Also, if you're a lead buyer, I want to make sure we also send a link to a poll that will be on LinkedIn. And this was, I call it like an industry pulse poll. As we're looking at these impacts and we're redesigning our models, which is really what's going to be happening, and the discussions that have been ongoing, we wanted to know, or at least the REACH Association, all of us were interested in this part. If you're a lead buyer, the question is, will you be requiring one-to-one consent? And it's three options, but really what they're trying to get at is, one, yes, you realize you need that one-to-one consent is in scope and you need to be compliant for that. Or two, you say, hey, I manually dial. I don't use, quote, regulated technology in your outbound calls, so you don't think that's a concern for you in your normal lead generation outreach. Or there's a third option. So the Reach Association was just trying to get a larger input from others. So please take a look at that link on that Reach poll and provide your responses. And there'll be those that will be looking at that to try to see the industry impacts associated with that. So thank you much. And Gary, how is the TCPA enforced? Some know this, some may not. It might be new, but if you can give us a crash course on how the enforcement happens, that would be great.
Sure. So the TCPA is a really impactful law because it has what is called a private right of action, meaning individuals can sue. And if individuals are allowed to sue, that means then class action lawyers will start to sue. If you have a law that does not have a private right of action, then the only one that can enforce that is the regulators who have been authorized under the statute. So the TCPA can be enforced by both the regulators and the class action lawyers can come knocking on your door. Now, why are the class action lawyers interested in this? It's because damages for a violation of the TCPA can be up to $1,500 per call, per text. So multiply that by the number of consumers you might be reaching out to if you have not complied with the TCPA, and there's a lot of money to be had there. And regulators are trying to make businesses do the right thing, protect consumers, and get corrective action. Class action lawyers are after the money. That's it. In fact, class action lawyers don't want corrective action because they want to be able to come back and sue again other parties making the same mistakes. So it's always those laws that have the private right of action that are really the riskiest for businesses because you don't know where the hits are going to be coming from. It could be the regulators. It could be a lawyer in any of our 50 states.
Yeah, absolutely. And I know when there's development of privacy laws, that's always a debate about whether they should make that subject to private right of action. And then they'll pull in the TCPA and say, well, it certainly gets people's attention, but then it can also be, quite difficult for companies to comply with those things if there's private right of action can be sued in court. So the rules are laid out and then it plays itself in court and over in many different cases and instances, which everyone follows very closely. Yeah.
And to give the other side of the argument, because obviously you can tell by the inflections of my voice that I think private right of action is not a good thing. But the argument in favor of a private right of action is that the regulators can't go out against every bad actor. They don't have the resources, they don't have the time and the people. So if you enable private citizens through a private right of action to bring claims, then you sort of have this huge regulatory police force out there doing the work on behalf of the regulators going after bad actors. So that's the argument in favor of a private right of action. But if you're on the business side, yeah, you certainly do not like it.
Absolutely. Yeah. And one of the industries which they specifically mentioned, or I shouldn't say industries, but one of the lead generation models that was clearly in reference was the comparison site models that they mentioned there. And this is, let's say one of the more traditional forms of lead generation. An individual is on a page. Let's put aside whether the content is relevant to that, but they've ended up on a page and they're interested in finding out more information about a particular product or service. And they will say, please provide your information here, and we will have a number of interested parties and companies contact you by telephone or by text. This is the comparison sites model. The technology sort of behind that was called ping post before. And our analysis and looking at these changes with the one-to-one consent, we think there's definitely going to need to be a change here where the consumer is going to need to be presented a choice about where they can share their information with. So those models certainly need to take a look at that. And we've put forward a model called ping pick post. Okay, this allows the consumer to enter some data. They're going to ping the interested potential buyers, and then the consumer will be presented with an offer or identified as an interested customer that they want to hear from. So please take a look at our site ActiveProspect to learn more about ping pick post. This is a model we have presented. We want feedback from others. would this work? Would it not work? It's going to help us identify the solutions that we can help bring to the industry, and all are interested in continuing that model of comparison sites because there really is consumer value in that. But clearly, there will need to be a change presented there as well. So please take a look at that. You can also just Google search ping, pick, post, and find out more information there. And also wanted to mention, there's obviously going to be a real focus on, well, there always was with TCPA, but the consent language and notice that is going to be presented at the time of the consumer individual entering their information. Was there anything significantly changed in the last month updates related to the notice and language that needs to be provided, Gary?
Yeah, I mean, it's all tied together because this idea of consent, what is consent? Some new privacy laws define the word consent and borrow that GDPR definition of, informed, unambiguous, freely given, specific. And so what does it mean to give consent? Because if a disclosure is buried way at the bottom of a page and the button to give your consent is at the top of the page, some would argue that's not consent. And there actually have been TCPA lawsuits because disclosures have been below the button where somebody opts into something instead of above the button. So it's always about, and I like that GDPR model, about making the disclosure and the consent unambiguous. I mean, it should be very, very clear what somebody is opting into before they provide their number. And the magic words that the FCC uses in this new order are logically and topically associated. So again, going to our examples that you say, I put in my phone number here to get text messages about vacation packages. Is it, logically and topically associated that I'm going to get it from, Fred's tourism company that operates out of his mom's basement? I don't know. I never heard of them before. It doesn't make sense. We always talk about one-to-one in this new issue, but if the disclosure very hypothetically said, I agree to receive text messages from Coke and Pepsi, well, then you know who you're getting text messages from. And it is logically and topically associated with the ones who are identified in the disclosure. So there are ways to structure the disclosures that may involve more than one company, but then still comply. And you really need to put yourself in the shoes of the consumer. Think about when the consumer pulls up their phone, opens up their text messages, would they see the message and say, I know why I'm getting this because I signed up for whatever. But if they're going to look at that text message and say, I have no idea why I'm getting this, then that's the problem the FCC is trying to stamp out.
Yeah, and as privacy officers, and even compliance officers as well, really tuned into that notice language and the importance of it. I know my marketing peers, I love them, but they're just looking for what's the most simplest language, 5 words that I could say that's going to agree to have them so that we can contact them and do whatever forth from here. But that's not what these changes are about. It hasn't been about that previously, but they're just emphasizing that even more. So from compliance and privacy officers out there that are getting tuned into this, the notice language is going to become increasingly important. Work with your legal counsel so that it can understand your business model and your outreach and marketing approach and the data that you're collecting and processing and doing outreach so that they can help you draft the best language that's going to give you the most flexible and consent and transparent part for the language.
Yeah, I mean, and Benjamin, I'd also add to that. I mean, again, when you're dealing with a class action lawyer, you can't really reason with them. Say you were dealing with a law that only had regulatory enforcement, and you come up with your disclosure language and your requirements, and you think you have met the spirit of the law. You could argue and reason with the regulators that we are protecting the consumers because we are meeting the spirit of the law in the way we're doing this. Maybe it's a little bit different the way then you may have seen others do it, but here's why it works. Now, with a class action lawyer, those arguments don't work. They want to find any slight little issue that can validate a claim for them to seek money damages. So again, I did mention these are real cases where you had a disclosure and the button to consent was above the disclosure. And they argued that consumers did not see the disclosure because it was below the button. So they would put in their telephone number, they would click OK, and the disclosure was below the button, and class action lawyers are like, I got you now. And again, they're just looking for money.
Yeah, and some other quick wins: no pre-check check boxes, avoid that action.
Yes.
You will become familiar also with the term of dark patterns. You says, I didn't know we were practicing Harry Potter magic here in the space, but apparently that if you look at that in the FCC, and I think the FTC also have been providing guidance about dark patterns, which is just making it not obvious for a pathway. Someone is continuing and, different sides of the buttons, color, all those sort of things really get into that whole space of dark patterns and the traction of getting people to agree and sign up. And those aren't viewed very favorably at all.
Yeah, I mean, with dark patterns, that's a really important issue, Benjamin, that regulators are looking at dark patterns, and it's popping up in new privacy laws that are prohibiting dark patterns. And those can be act or practices which obscure choices or make it confusing or inadvertently rope consumers into certain things. For example, if you were, trying to get someone's opt-in consent and it's like, yes or no, do you agree? And one button is really huge and the other button is really tiny. Or I've seen ones where you can't even tell which is yes or no. It's like, do you not want to stop receiving text messages? Yes or no? I think, well, wait a minute. What does that mean? So those dark patterns to trick consumers drive regulators insane, and they are all over those these days.
Yeah. So the notice and consent language is foundational. It's becoming super, super important. It's not just a fine print item anymore. It needs to really be reviewed, carefully analyzed, and presented. Trusted Form solution from ActiveProspect is great to capture that consent transaction on web forms or on web apps, and we have partners that use that system and document that consent transaction as it happens, that point in time. It can be saved in your CRM. It can be used in TCPA legal defense cases because it shows here's exactly what happened. Here's the language at that date and time, the things that were presented, and we archive that for you. I also want to mention we have a great feature called Trusted Form Verify, which is new in our space. And it's a solution that's going to get closer into language. I mean, previously, the responsibility, which it still is on the brand or the lead generator partner to provide the correct notice language, and that still exists. But we wanted to help the industry with more insight about can Trusted Form look at the language that's being presented as it comes in more real time? Can you train it the things that you like or don't like and sort of do audits as you're going, or even dismiss leads that come in that may have some problematic consent language? So if you're interested in that, please take a look at the Trusted Form Verify solution, which just came out last month. But we'd love to have more input from you on that solution as well. So please visit that page and take a look. Also, for the impact to small business, I think I failed to mention the comment period was February 26th. So if you followed that TCPA World link and from Reach, that's a time period in which by February 26th, if you're a small business and want to provide a comment to the FCC, now keep in mind, this is on the record. So please be respectful and follow the instructions for providing those comments if you want to interact with that. But
and maybe comment on the small business issue. So this came up in the proposed rule, both in the rule and in dissent. They were both talking about the impact on small business and arguments either way. In the rule, they said, we think this actually helps small businesses because small businesses, they're having data sold through lead generators all over the place, and they're getting calls and they're getting messages from people who really may not be appropriate consumers from them. And it's taking up time and resources from small businesses because they're getting worthless leads and they're getting, messages from people who want to opt out and stop. And they think that it's not good for small businesses that data is being sold all over the place. Of course, the contrary argument is that if you make it harder for the lead generation business to operate, then that's the only way that small businesses get new customers. They rely upon data brokers, which we'll talk about in a little bit, and lead generators to get businesses for the new customers. In my example earlier, I talked about Coke and Pepsi. Yes, you know who they are. But if it was, Bob's new microbrewery, you may not have heard about them, and they rely on lead generators and data brokers to get them customers.
Yeah, and the small business comments was interesting because there was a comment period before that when the rules were in draft form, and you could see that, and there was also good comments that said this is going to impact small businesses as well, and they also said in their response that there will be some draft compliance guidance coming in the weeks and months ahead. So that was the opportunity to provide input back as well. The other impact that it will have, and I know this will significantly impact many in the lead generation business, but it could have potentially more of a positive impact. It's increasing the price of the lead or the quality of the lead. So instead of being so comfortable with high volumes of leads, which may not have been collected on the most appropriate terms or sourced correctly or pulled from lists or all those sort of relevant areas, which only lead to troubles for outbound calling and everyone in this space. If there is a focus to have higher quality leads, consent, fully validated, more transparent, collection, processing, notice terms. Yes, lead volume could go down, would expect it to go down, but quality would go up, prices would go up in that space too. So that's also potentially some value for small or medium businesses when saying, instead of having to chase 1,000 leads, maybe I have less, but maybe those leads are of a higher quality. So it's also an interesting impact that could happen on the industry perspective here as well for small and medium business, or really for all of us. One item to mention, so if you're not following privacy law developments, you might think that's just a completely different continent that's floating away, but there is sort of an interconnection or themes, and I know, Gary, you follow that space very, very closely and quickly. So tell us about those developments outside the FCC with the FTC and state laws and, the themes that you saw in 2023 and things that are clearly going into 2024 from privacy laws that have an interesting connection in the direction that things are going to go regardless of processing personal data.
Sure. Many people are familiar with the new privacy law in California that's been around for 4 years, the CCPA, the California Consumer Privacy Act, but we now have 5 states with comprehensive consumer privacy laws that are currently in effect. And there are another 8 that have passed laws that will come into effect over the next 2 years. So as we sit here today, there are comprehensive consumer privacy laws in California, Virginia, Colorado, Connecticut, and Utah. During the summer, we're going to get more from, I think, Texas, Montana, and one other come into effect. And then in 2025 and even 2026, there are some more that are taking effect. And these laws are all different, which makes it really challenging. There's not just one strictest standard where you can just point to and say, all right, I'll just do that, and that will be it. And one area where they are inconsistent and that impacts our conversation today is about how you get opt-in consent to process sensitive personal information. So some states have an opt-out process for sensitive information. Others have an opt-in process to collect sensitive information. And they all define sensitive information in a different way. So if you were hypothetically getting consent to send text messages and a disclosure, and at the same time you wanted to get consent to collect geolocation data, then you would need to separately call that out, because those are 2 different issues that both require affirmative consent. So it's when you layer in these other purposes for collecting the data and the other type of information you're going to collect, it can become very challenging. And forgive me, I'm not sure if you can hear my dog barking in the background. I think she's trying to opt out of some unwanted text messages, but she doesn't have any thumbs, so it's making it really frustrating for her. But these new laws are coming up all over the place. And at the same time, the federal government is enforcing privacy law, but there is no comprehensive consumer privacy law on the federal level. We talked about TCPA. There's laws about protecting children's data, healthcare data, financial data, but the Federal Trade Commission, the FTC, is able to regulate deceptive and unfair practices. And they use that jurisdiction very, very broadly. Within just the past few months, they have brought enforcement actions against data brokers who are selling location data that could possibly be used to identify sensitive locations, such as a healthcare clinic or a school or a house of worship. And there's no federal law that says you can't collect and sell location data. But the Federal Trade Commission is arguing that collecting that data and selling it is an unfair practice, meaning that it's going to harm or could possibly harm a consumer, and it's not outweighed by any other benefit. So the FTC, in the absence of a federal comprehensive consumer privacy law, is getting very, very aggressive on what is deceptive or unfair. That's an incredibly subjective standard. So you want to always think about your practices and think if it could trip up that standard.
Yeah, it allows them to go in a lot of different directions for what they want to investigate or review for unfair and deceptive practices. So it's flexible in that regard, but it can be it for compliance officers and everyone. You've got to be cautious, be conscious of it. And it's interesting with the focus of the growth and focus for data brokers, even at a state level, because lead generation and marketing is always going to have an interested relationship with data brokers, because you come to lead generation to gain new customers. You can also additionally use data brokering to find out more insightful information about those customers, to find out who will be your best customer. But it can get problematic, so be careful of that balance and make sure that you tune in the industry laws that are applicable to you in that space. When it comes to marketing and the use of data brokers. And like I said, states are focusing very much on that and individually. And you said how many states have passed data broker laws or are about to? What's the development in that?
So with data brokers, there are now 4 states that require data brokers to register with the state registry. The first one was Vermont, long time ago, and no offense to anybody who's on the line from Vermont, but quite a small state, so most companies ignored it. The second state that passed the law was California. Now everyone wakes up and pays attention. And then just last month, Texas and Oregon, their data broker registration laws came into effect. So we now have 4 states where if you are a data broker, you're required to register and you will be listed on a public registry. Now that sounds simple enough because you fill out a little form, you give a link to your privacy policy, and you pay a couple of $100, and that's it. You're posted on a website. California has taken this a very, very significant step further. And again, let's be clear what a data broker is. Data broker is a party that does not have a direct relationship with the consumer, and they are selling the personal information of that consumer. So very much related to lead gen, that if you want to find new customers, you go to a data broker to buy the data. But if it becomes harder for data brokers to collect and sell this data, then it'll be harder for those who want to buy it. So I was saying California took this to a whole new level. The 4 existing laws were just merely a registration exercise. You do it and you're done. Now, if a consumer actually wanted to opt out from all of those data brokers, I think the California registry now has, my numbers are probably off, 600, 700 registered data brokers. If you wanted to opt out from every one of those data brokers, I would argue that would take you weeks of working full time on doing that, because you would literally have to go to the registry, go to a party's privacy policy, read the privacy policy, and find out how to opt out. California has passed what's called the Delete Act, and this is going to take many years to implement. But basically what they're going to do is they're going to turn their registry into a one-click opt-out. And so instead of spending literally weeks and hundreds of hours trying to opt out one by one, you'll be able to click one button and you'll be able to opt out of all the registered data brokers. And the way they're going to set this up is that the state of California is going to build an API, and all the registered data brokers have to integrate with the API so they can receive opt-out requests. And to go even further and prevent the data brokers from reacquiring the data, to make it permanent, the data brokers are going to be required to refresh their opt-outs every 45 days. So really, once you opt out, you're gone. And there's 39 million people in California, so that could be a lot of people and potential customers to lose.
Yeah, and then on the back end, the technical implementation of how to make all that work and happen is obviously going to take some period of time. But you can see the direction and themes related to privacy and respectful processing of data and transparency and all that, just continuing and everything that's developing. So yeah, California Delete Act. Going to start hearing more about that. You said there's a longer window. I mean, is that a bill, or has that been passed, or what's the time period for that? So we start looking closer into that.
So that has been passed, but they realize it's going to take California time to build this out technically. This is not what they typically do. So I believe the timeline is that California is supposed to have the technical implementation done by early 2026. And then by August 1st of 2026, all the registered data brokers need to be integrated with this new technology so that they can process these opt-out and deletion requests. And then one more challenging thing in the law, by 2028, all the data brokers are going to be required to get an independent third-party audit to verify their compliance. So there's really, really a lot going on there. And I think to your important point, Benjamin, about what the trend is here, the trend is to give, at least from the regulator's perspective, more certainty to consumers so they know exactly who they're dealing with, and it's easy to get out of that relationship. The concern now is that your data gets into data brokers and lead generators, and it flows all the way around, and you have no idea who has your data or how to control your data. They want to change that. And that's why a lot of businesses are focusing a lot on first-party data. So if you're a retailer, for example, and you have that direct relationship with the consumer, that first party data is incredibly valuable because all of these laws are not focused on making it more challenging to collect and process first party data. It's all about the third party data and the sharing and brokering of data.
Yeah, and I see that with the clients that we work with. It's a combination of both. Some of them have a real robust brand and have a strong first party relationship and want to capture and document the consent associated with that. And then the leads, then they perhaps want to open it up to other third parties to present and good valid leads. And some of it would be skewed the other way, where there's very little first party relationship and all just third party of anyone who could present a good qualified leads for them to be able to process. So there's a lot of trust in that chain when you go throughout. From a compliance officer standpoint, I would just say the takeaways related to data brokers is make sure you are aware of those entities that you have a relationship with, which could be considered data broker, right? It's argued and it could be subjective at a certain point. You'd have to look at the individual laws, but it is something to become aware of as you make sure you understand that relationship and how it's being processed and that data is being used in your company, so you don't potentially run afoul of something that's going to put you in scrutiny later on. Regarding the FTC TCPA update, there's been there's a longer period of time, or 12 months until the implementation period. We do caution everyone, don't just set a snooze alarm for 11 months and start working on this. You need to start working on it now. A good outline is the first 6 months, looking at your business model, consider whether you need to make changes, connect with legal counsel as well to get familiar with your business to see if there's do you need to change site design? Is it just an instance of notice and consent language? Like how heavy of a lift is it going to be for you? But then also the longer piece of that is legal contracts with third parties that you use in the lead generation space. So when you looked at that one-to-one consent update in the TCPA update from last month, what was your sort of takeaways on how this is going to impact over the next 12 months of developing contracts in this area, Gary?
Yeah, I mean, you really want to look at, existing contracts, see if they need to be updated, and then, of course, new contracts. And, contracts are somewhat about finger pointing. Who's responsible for what different part of the project? And think hypothetically, if you were a brand and you were hiring someone to do some lead gen or text messaging on your behalf, but you as the brand said, I'm going to draft the disclosure. And maybe you drafted the agreement, 2 or 3 years ago. Then once this new rule takes effect, that disclosure may not be compliant. And so maybe you as the brand are responsible and not the vendor that you hired to do the text messaging, because you're the one that made the disclosure. A lot of contracts will just say each party will comply with applicable law, but you got to go a little bit further to see what are the obligations there and who's responsible for drafting the disclosures and who's responsible for approving the disclosures, because that's where the liability can come about. So you really want to look at those old contracts as well as update forms for new contracts. In addition, as Benjamin and I have been talking about, there are a lot of new privacy laws out there, and many of the new privacy laws require a DPA, a data processing agreement or data processing addendum, if you have a processor or service provider that's going to be processing your personal information. So if they are doing any work on personal information that you as the business, as the controller, own, some of these state laws require that you have a written contract with specific terms in that contract. So if you haven't done that in the past, maybe you thought DPAs were mostly a European thing. Well, they've come across the pond, and now we have to start doing them here as well. So especially old contracts, you really got to pull them out, blow the dust off of them. They've been sitting in the drawer, and the fact that they were signed and sealed years ago, they may be invalid in today's new world.
Yeah, excellent points, and true. Those did start in Europe, and they are making their way over here with those specific requirements. So, align yourself with good legal counsel and representation in this space, and a long plan to get that done, and you'll be appreciative of with the thinking of everything throughout. If you're thinking about that ahead of time and not rushing to catch up. Gary, I know, you in the marketing and MarTech space, there's a lot of things that you're tapped into and a lot of different clients and advise. I saw you went to the IAB conference recently. What were some of the takeaways or things that you saw at that event that you think might be relevant for those in the lead generation space here?
Sure. Yeah. The earlier part of this week in Florida was the Interactive Advertising Bureau's annual leadership meeting. So it's the IAB's ALM conference. It was in a nice location, Marco Island. And there were, I think, about 1,200 attendees there. And it's interesting because I've been in the digital media and privacy space for over 2 decades now. And it used to be that privacy and data processing and those issues were just a tiny, tiny little part of the conversation. And now they dominate the conversation. Everybody's talking about it. And of course, with the deprecation of third-party cookies through the Chrome browser, which is now in testing mode, 1% of users are having third-party cookies blocked in their Chrome browser. With Apple and their ATT program, you all get those pop-ups asking if your app wants to track you across different apps. We're moving towards this opt-in model instead of the default opt-out model where everybody can be tracked everywhere until you opt out. The privacy laws that Benjamin and I were talking about are mostly opt-out, except for sensitive personal information. But industry, Google and Apple specifically, are making more of an opt-in model. So it's making harder for businesses to collect and process data online. If you're involved in retargeting and behavioral advertising, third-party cookies go away in Chrome, then it makes it much more challenging to target those users. There are many alternative solutions that are being proposed to use different types of persistent identifiers in order to still target people. So businesses are trying to look at how to keep targeting consumers and acquiring them when the old model of just buying and using third-party data is going away.
Yeah, it's interesting. A lot of times that would have been maybe the last discussion on the day before everyone's about to exit. And I think you noticed in the trend, it's moving much further up the presentation chain to being more relevant for the use of personal data in all that space.
Yeah, and some parties, think that they are compliant, but not. I'm not going to name the brand, but there was one brand at the IAB's conference, a very major brand, and I think it was like their chief marketing officer or somebody very, very high up from stage said, we only collect data with the consent of the user. And a lot of us ad tech people looked at each other and were like, I'm going to go to their website and see how many third-party pixels are on that website. I bet you there's a ton. And they're not collecting data with consent only. They're operating an opt-out model, which is okay for most of the state privacy laws in the US. But don't oversell what you do in terms of privacy. be accurate, because you can get yourself into trouble if you try to oversell what you do by saying we never process certain types of information and we only do it on an opt-in basis and we never sell personal information. I put air quotes around that because these new privacy laws define the word sale unbelievably broadly. Yeah. So just be careful in what you say in your statements publicly, online, in blogs, of course, in privacy policies, because regulators might look at all of those statements and view them as your company's representations.
Yeah, absolutely. Yeah, you don't want to oversell, or if you don't understand the technology around some of those things, you want to be very careful about summarizing it very quickly that you're in 100% compliance space with all personal data. That you can definitely stub your toe in the middle of the night on that one if you're being too wide in your declarations there. Also, very quickly, you're involved with the Performance Marketing Association. Any comments about the developments from them as well? I know they're following this space as well, sort of colleagues in the lead generation space as well.
Yeah, the PMA, the Performance Marketing Association, is an association mostly in the affiliate marketing industry, which relies very heavily on lead gen. So they are certainly following this issue and posting about this issue as well. Because in the affiliate marketing world, yes, you're always trying to find the consumer that will ultimately click through, make a purchase, and then the affiliate marketer will get a couple of pennies or dollars as a result of that. So trade associations are talking about this, and it's always very important to stay close to whatever trade associations are relevant for your industry. If you're a brand, maybe it's the ANA, the Association of National Advertisers, ad tech companies, the IAB, affiliate marketing, the PMA. There's an endless alphabet soup out there. I'm sure you can find one that's appropriate for you.
Yeah. Know your association that's closely represents your industry, because they can help you translate this, and as the group together can help you with information about the most impactful things. So also like to make sure we mention what they're working on and encourage people to be members in those associations and outreach as well, those that are applicable to you. Before we shift to questions, which we'll open up in a second, any key takeaways, Gary, that you would want to share with individuals here to possibly make it an opportunistic view of the future with all this data regulations coming?
Right. And I think, maybe you hit on one of the most important things, that, volume may go down, but quality can go up. And sometimes people are just, too focused on volume and not quality. So I think you want to look at, when you're collecting data and you're processing it, you really want consumers that want to engage with you. I represent a number of data brokers and ad tech companies, and when they get opt-out requests, a lot of times they just delete the data because they're like, obviously this is a consumer that doesn't want to interact with me at all. So why would I have them in my database? It's probably a risky consumer. If they've already indicated they want to opt out of sales or retargeting, I might as well just take their data out completely. So I think the focus on quality will be a growing trend throughout all the ecosystem. And I would encourage people on this call to do that as well. Don't just focus on just churning and bringing in a huge number of leads and data points. You really want to look at what's the ROI for that data that you're getting. And sometimes less data can yield a better ROI.
Yeah. And I know your firm presented an update about the FCC TCPA update. So we'll post that here in the chat as well. And you also look back at 2023 and forward into 2024 in a great article with some, grouping of items to be talked about, which we touched on, not all of them, but a number of them we did touch on today. So we'll share that in the chat here as well. So shift into questions in the questions section. I'll grab one for you. Is there still the possibility that the FCC will revise the one-to-one consent or something like 1-to-5 or abandon altogether? Thoughts?
There's always a possibility. Like we said, the comment period is still open. They're getting comments. They're digesting comments. I think when I read the proposed rule, that the commissioners, except for the dissent, were really mostly aligned and really focused on doing this. And I doubt there will be enough, voices or sway in the comments to change their mind. But there's always a possibility that something happens that will change their approach here.
And I will say in the comparison model, it can be 1 to another entity, but it just has to be clear and the consumer has to make the choice that they would want to hear from two companies or three. You want to give them that position to do that. So even though it's one-to-one, because that narrows down the focus of what we're talking about, or we could succinctly sort of understand the significant impact of that, it doesn't preclude additional outreach, but the consumer needs to be aware of that and agree to that sharing of information.
Yeah, and kind of analogize to where this is happening elsewhere in privacy law. Washington State has this new healthcare privacy law called the My Health, My Data Act, and they require consent in order to collect health information and what they call separate and distinct consent if you sell that data to a third party, and you have to identify the third parties. So again, in terms of trends that are showing up in these laws, it's really about making it extremely clear to the consumer where their data is going. Because the fear is that currently, under the current opt-out world model we have, that data gets into the ecosystem, flows throughout the world, and then you're playing whack-a-mole trying to eliminate your data, which is next to impossible.
Okay. Another question is, how does this affect a call center that usually buys data from data vendors and cold calls? These are calls that are a major contributor to customer inflow. So buying data and then call center doing cold calls.
Right. And, that's a great question and almost might take a little digging more into the order to look at it, because the proposed rule was so focused on text messaging, but calls are definitely subject to the TCPA. And how are those numbers generated? Are you generating the phone calls just through a random number generator through an auto dialer, which is certainly covered by the TCPA? Can't do that without the proper consent. Or are you buying the data from a lead generator, in which case they may have acquired the data online. And again, they should have gotten that one-to-one consent. So TCPA absolutely applies to calls as well. And this proposed order and rule is going to impact calling as well for that industry.
Yeah, would require a little bit further explanation, digging in about that. But, the term cold calling, you would say generally not preferred, although there are ways in which it could potentially be performed. But, the theme is consumers know that they're being contacted and understand why they're being, why there's an outreach is going to put you closer to being on the right side of
Yeah, and not to go down the weeds too much, but again, if someone's on the do not call list, you can't call them. But if you're using an auto dialer, it doesn't make a difference if someone's on the do not call list. You would need the prior express written consent for a marketing message, or just prior written consent for an informational message if you were using an auto dialer.
Okay. Yeah. There's a question about international call centers. I'll narrow the focus of that one a little bit too, to frame that. So let's go with the unsolicited grouping. The FCC is working on a whole bunch of different technical initiatives to stop the thing we all agree as being evil robocalls, totally unsolicited, even fraud as a service, trying to contact individuals and trick them. And there's different initiatives that they're working with the telcos to try to stop that traffic, right?
Yes, absolutely. And part of this FCC order that we're talking about here requires the telcos to take more steps when the FCC notifies them that spam text messages or calls are coming from a particular number or location. So it's going to require the telcos to do more to block those fraudulent messages from coming in. And there is a whole section, I don't have it in front of me at the moment, about what the telcos are required to do both on their own and when they get a notification from regulators about blocking a number.
Okay. Yeah. Looking through any other questions, even if there's one that you see that you think is good to answer. Does consent come with a timer? That's a good question. Valid until what date? There's a few specifics about that, but that's a good broad question. What would you share with that?
Yeah, that's a very good question. There have been laws proposed laws at time about refreshing consent. But I don't believe that that's the situation here. I could always come up with a hypo where you got consent for something in 2024, and then in 2028, you're sending a message really about something radically different, even though it might be from the same company. And then remember those magic words that I said earlier, it's not part of this order, but a lot of new privacy laws talk about consent being unambiguous, specific, informed. And so I know in GDPR world in Europe, there have been a lot of enforcement actions where consent was not specific to the activity. So it's not enough sometimes just to get the consent for a particular company, but to get consent for a particular company for a particular use. Again, going back to one of the things you said very earlier, think about it from the consumer's perspective. When the consumer gets that message, it should spark in their mind, I'm getting this message because I signed up for X or Y. It shouldn't be a complete mystery to them why they're getting the message.
Yeah, and in the outreach and telemarketing space, when I see that question, I think of the established business relationship rules, the telemarketing sales rules, which I believe is governed by the FTC, right? If I'm not mistaken, that's their jurisdiction. You could get closer to some general guidance for your business that's applicable. Again, there's some specifics there. Is this informational outreach? Is this selling a product or service? Is this marketing? Like those kind of things. But for timing of that, I usually try to go down that pathway and look at what that guidance says from the TSR, from the FTC about business relationship, because I do believe there are some periods in which they identify if a customer, if you have not had any outreach or interaction with the customer over X months of time, and I forget the exact time period, it says probably not a good idea to contact them out of the blue would be a good area. With that, we've got a number of questions. We'll gather these and see if we can. We're going to write a summary article about that. Maybe we can drop some of those other questions in the summary article that we'll draft after the event. But Gary, certainly want to thank you contributing your insights and knowledge here today. And is there anything you'd like to share in closing comments?
I just think last thing, it's just like make sure everyone in the organization, marketing and legal, work together, because marketing, of course, want to be very aggressive and do everything to get customers. Legal is being very, very risk adverse. You need to come together and work together to come up with the right disclosures and the right processes, which will both accomplish the marketing goals, but not put you into legal jeopardy.
Absolutely. That is rock solid advice. I want to make friends in all the spaces, all the friends, all the fields, marketing, legal, compliance, technology. Let's all get through this together. There's some good opportunities with these rule changes, so certainly be aware of the opportunity which it can unlock for our industry. It's an opportunity to turn things really positive and make some changes and go in a great direction. A quick note: we're going to have our next episode 3 is going to be on February 14th. With Alexandra Kosovic from Manet Law Firm. And in that one, we are going to be digging into a little bit more about SMS and text messaging compliance from a marketing perspective. So if that's something you're interested, keep looking out for more information and articles from us at ActiveProspect. And thank you all very much.
Thank you.